dishonest agents of companies. Rule 1.13 deals with our representation of an organization. And when the lawyer is engaged by the organization, that's who the client is. Even if they're and of course it's acting through authorized constituents, but like officers, directors, managers, whoever. But it's the organization that we represent. And if we learn that an officer or other person associated with the organization is engaged in actions or is planning to take actions relating to the subject matter of our representation, and that the proposed course of conduct is a violation of a legal obligation to the organization, or a violation which may be imputed to the organization and result in substantial injury, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization, as opposed to the agent. So if we learn that an agent is engaged or wants to engage in conduct that we think is inappropriate, can cause substantial financial harm, we don't protect the agent, we protect the organization. And so we need to advise the agent. And if the agent that we're dealing with, the agent refuses to take corrective action, then we are obligated to go to a higher authority in the organization, if warranted, to the highest authority in the organization, to make sure somebody in charge knows about the dishonesty or intended dishonesty of the agent. And if, despite our efforts, by taking the matter to the highest authority on behalf of the organization still insists on taking inappropriate action, and if the lawyer still believes that it's going to result in substantial injury to the organization, then the exception to similar to Rule 1.6 comes into play, which is the lawyer may, again, it's permissive, reveal information related to the representation, whether or not it's protected by Rule 1.6, which is the duty of confidentiality, to correct the situation. Now, Rule 1.6 already applies to this situation because the corporation is the client, and the corporation, acts through its constituents. We still have the rights and the permissive rights under Rule 1.6. But this merely reemphasizes the fact that we have that right, in fact, to some extent have a duty to make necessary disclosures. The rule makes clear that it does not, the prohibitions of this rule do not prohibit us from investigating on behalf of the organization alleged wrong. So if we're hired to come in and make an investigation on behalf of a corporation as to what went wrong, we're not prohibited from doing that. And the rule also makes clear that if we have been discharged, and we think we've been discharged for our exercising our obligations under B and C, then we are to let somebody know higher in the organization that we've been discharged as a result of that disclosure. And then the rule also reemphasizes that when we're dealing with an organization's directors, and we learn or believe that the organization director, officer, employee, or whoever thinks that we also represent them, we must explain to that person the identity of the client, i.e. that we represent the organization, not the individual, and that that we're not protecting the individual's interest or rights. So all we should be telling them, if they deem necessary, is they should get separate counsel. But the rule allows us to represent directors, officers, employees, or whoever associated with the organization, but as well as the organization. But to do so, you create potential conflicts of interest under Rule 1.7, which is the conflicts rule, where you have two existing clients in a conflict situation. An example of this would be where the corporation and an officer is sued for the same act, for example, a sexual harassment claim. The corporation says, we're going to defend ourselves, but we also want you to represent, we're going to have you represent us, and we also want you to represent the employee who's charged with the harassment. well, then you're representing two people with a common interest, probably not a violation. But at some point, it could be found or determined that it is, like when the employee admits to you that they have violated company procedures and practices and that they, in fact, engaged in sexual harassment, and that this person told higher-ups that they were engaging in sexual harassment. Then you would have a conflict of interest under Rule 1.7, and you would have to disengage from representation of both the organization and the individual unless you had a future waiver of conflicts, which is what you should do, so that if a conflict arises, you can continue to represent one or the other of the clients. Generally, you'd want to continue to represent the organization, jettison the employee to get separate counsel. Future waivers, by the way, in this type of a situation are enforceable. So if you, they're enforceable generally, but you have to have disclosed enough information like that everything you tell me I'm going to convey to the other party, that there are no conflicts and you waive them, although you have the right to revoke it. And if you do, I continue to represent the other side. And that you talk about the repercussions, the negative repercussions from dual representation, then a future waiver can be enforceable. But when you're dealing with a lying or dishonest officer, and the client or the corporation asks you to represent both the corporation and the individual, there is a potential for a conflict that you need to be aware of. Even though it's permissible to do dual representation, it is craziness not to also think about the potential for a future conflict.